Today we're talking about necessary estate planning documents and what's the purpose of these things. So we're going to go through each one of them that we feel you need, and we're going to talk about what the purpose is. So Tom, speaking of purposes, what's the purpose of, why are we doing this video? Why are we going over estate planning documents today?
Yeah, I mean, we're doing this video because when we're doing planning, we want to start with the end in mind. And the end is going to be, what happens to all my stuff when I pass, or what happens along the way, what things need to happen before we get to that point. We have a podcast that's called Finishing Well, and part of that is needing these documents in place. And about 40% of the country don't have any of this stuff. They don't have a will, they don't have any of these things, and we could tell you story after story where things have just gone terribly wrong because that planning wasn't done. And so what we want to do today is just go over the important documents, things that everybody needs. Some documents that you might want, you might not need. We'll get into that. But again, you need to take this seriously. And if you haven't done this planning, you really need to sit down and get this done. And so let me bring up the show notes. You can find these below at the link. Because when we're doing planning, they're also on our website at cardinalguide.com. And we have the board, what happens to all my stuff when I
we'll
pass,
get into more
or what happens
but it
along
really
the way,
does
what
give us a
things
really
need to happen.
good
A definition and really explains what each of these documents are. And so when we refer to them, we'll give you some details as we go through the show. But if you want to go back and read this stuff and get a little bit more, explanation, like, what was that? Where things have just gone terribly wrong. Really good summary. And so what we want to do to show notes. So take a look at it. But we'll give. If you watch the video, you'll get a sense of what everybody needs. So I'll turn it back to Hans here, and we'll just get going on the first one, the revocable living trust.
Yeah, okay. So a revocable living trust, and you've probably heard us if you listen to a lot of our videos, maybe talk about these trust mills where there's seminars and there's 50 people in the room or 30 people in the room and everybody gets recommended the same trust. And then they meet later with the attorney and then they draw up a trust and they pay several $1,000s for this thing. And people are real proud of them when they bring them into us. We start asking them questions. So, that's the old trust mill thing that we as financial planners are not too thrilled with. Now, trusts have their appropriate place. And for very average people, they're a great way to avoid probate. So the probate process is very expensive. It's timely, it's confusing. It causes delays. So having a trust that goes on beyond your life that lays out distribution, that's what a revocable living trust can do. And where we've taken a little different posture on these when we recommend them is because some of the law firms that we work with through referrals, they don't charge as much for these revocable living trusts as you're going to get out there at the seminar. So first of all, bringing the cost way down for a simple basic trust, if that's all you need. It even has me at a point where I'm going to do one of these because it's only going to cost me $1,000. And that's, a pretty low fee to pay an attorney here in North Carolina that's going to do a revocable living trust for my wife and me. $5,000, not so much. It's just not that worth that much to me because the only thing that's going to pass at the end of my life and my wife's life, well, actually at the end of both of our lives, is the real estate. The only thing that would pass through probate is the real estate. And by putting that in a revocable living trust, it'll just pass to our children without going through the probate process. So there's other things you can accomplish with that. One of the things I want to point out with a revocable living trust is you can't put IRAs in a revocable living trust. And that's one of the things that a lot of our clients that have been to one of these trust mills and they've actually taken them up on it, we start digging into it. And these people, like a lot of people, most of their assets are in their IRA or their 401k. And that has to be outside of the trust. You can't put an IRA while somebody's living in a trust. So just keep that in mind that you can't transfer that, but you really don't need to because you have a beneficiary designation on a revocable living trust. So Tom?
Yeah, I mean, I think Trust can be very useful and they can do a lot of things that other accounts can't do. So we are not anti-trust by any means. But I think a lot of people are sold them and they think it's this end all be all, this greatest thing ever, when in reality it adds more complication than it's really solving. And so for us, that needs to have a purpose. If the purpose is clear, we are all for it. A lot of attorneys, not all of them, but a lot of them is like they put everybody in a trust because they think everyone needs one. And it's like we're a little bit more nuanced than that. But again, certainly it's a great useful tool when needed. When we go on to sort of the next one on the board, a last will and testament. And so everyone needs this. I don't care if you also have a trust. I got a story I could tell on that. But at the end of the day, the last will really lays out what your wishes are. And it goes through, here's where I want to have things passed to. One of sort of the interesting pieces of estate planning when we're helping people do that is a goal that we have is to have as much stuff pass outside of the will where it's not going through the will, it's not being executed, you don't have to go through probate. But things get missed, people miss titling accounts, they miss beneficiary designations. That will is sort of that catch-all document that picks up any pieces that don't have named beneficiaries, and we'll talk about that later. And it tells what your wishes are as opposed to the state saying what happens, because they have rules of what happens if you die without a will. Very clearly, here's what happens. And we've seen really, really bad examples of what that can look like. I'll give you one. I mean, we could spend all day talking about this, but we had a client came in. His father was running the business. The dad owned the business. The son was the client that we were working with, and we were talking to him, helping him out. He was set to inherit the business. We said, well, does your dad have all these documents in place? We asked the dad. He's, oh yeah, I got it taken care of. I don't really need your help. It's like, all right. So we sort of moved on. Fast forward a couple of years, the dad passed away. He did not have a will. He didn't have any of this stuff set up, and he had just gotten married, a month prior to him dying. He died unexpectedly. Well, now it was in North Carolina. It went to the intestate laws in North Carolina. That intestate just means you don't have a will when you pass. And what that stated was his current wife got half of what he owned, including that business that she had no connection with. She didn't run it. She wasn't in it. The son was set to inherit it. He now only got half of the business. He actually had to share that with his siblings. I mean, it was a mess. And so all that to just illustrate is you need to have a will. And then also, our goal is to have things not go through the will if we can avoid it. So, Hans, I don't know if you have any more comments on that.
Yeah, I just think if you have a trust, and we run into people that have very good trusts, they don't have a will. I mean, most attorneys, when they do a trust for you, they're also going to do a will because you need both. If you're still dying intestate if you don't have a will, even if you have a trust, and somebody can come in, one of your heirs, and open a probate just over the fact that you died intestate. Now, if all your assets were properly in the trust, they're not going to get much, but you need a last will and testament whether you have a trust or not. Okay. Um, the general durable power of attorney. And again, if you're a married couple, you can get by without these things. I mean, it's just husband and wife gets sick, husband's not going to have that much trouble signing for her. It's a little tricky with her IRA if she's got to do business on that. So let's just say that everybody needs this general power of attorney, husband and wife. And then you need to put down, if you're married, one of your children as the backup because you want these documents to last forever. I mean, like my wife and I mean, she's the number one on my power of attorney. I'm number one on her power of attorney. But our number two person is our oldest son, and on both of ours, so that one of us is going to die before the other, and the living spouse is going to take care of business for the spouse. But the one that lives on doesn't have her primary power of attorney. He's dead, which is me. And so have down as the backup one of your children and maybe even another one of them. And you're going to need this when you get old and we're dealing with long-term care. I mean, or maybe you're not even old yet and you're in long-term care. You're going to want all this stuff laid out so that they can do your business. Take your minimum distributions out of your IRA. Um, Sell your house if necessary. Pay your bills. Negotiate with selling your car. I mean, just doing all your business that you would normally do that you can't do. You need a trusted person. And that's what the power of attorney, the general durable power of attorney does. Tom?
Yeah, I mean, again, this is a document that's super important. And really, one of the things to know on this, and then also the healthcare power of attorney, which is later on the list, is that document ends at death. They won't talk to you after someone's died. That's just a small point. But while you're still alive and unable to do some of this stuff, this gives you the legal authority to act on someone's behalf. Again, spouses, sometimes there's a little bit of leeway with spouses, but certainly if you're a child, or even like a cousin or a nephew, whatever the relationship is, if you don't have this document, a lot of people won't talk to you. If you try to call up Charles Schwab, Fidelity, wherever the money is being held, and try to ask them questions about this without this document, they will not tell you anything. And so we've been through scenarios where someone's come in, maybe they've been diagnosed with dementia or they're on that route. They don't have these documents, but they've been locked out of their accounts. I mean, it gets really messy, very quickly. And so having this in place, and it can be a springing one, and all that means is it doesn't take effect until you're unable to perform those. So they can't go do stuff while you're still, have your capacities to do it yourself. But if you don't, they can step in, they can oversee what's going on. I mean, again, it's a very useful document. Hopefully it's never needed, right? I mean, everyone's goal would be to live a nice long life, die peacefully, no issues. But realistically, we know that doesn't happen all the time. And so this needs to be there to pick up those pieces, and have them be able to transact business on your behalf if you are unable to do so. The next one on the list is advanced care directive, or sometimes called a living will. And again, this really just lays out your wishes for end of life care. So, think of like, do you want to stay on life support? How long? What measures do you want them to take to keep you alive or not take? Right? There's a lot of times where we more see that. And the reason you want to have this is it gives instructions to your family, to your kids, to your spouse, to your loved ones of what your wishes are, because a lot of times when these decisions are making, you're not conscious, you're not able to tell them what you want to have happen. And so you need to have communicated that with them. Ideally, you've talked to them ahead of time before that happening. But if you haven't, at least having this document which clearly laid out what you want to have happen in your particular case is super helpful. It really helps minimize fighting within families, right? A lot of times, a parent, we'll use this as an example, parent gets sick. We have siblings that disagree on what measures to take to keep mom or dad around. One says, oh, mom told me this. The other one said, well, mom just told me she doesn't want that. I mean, and then there's fighting, there's resentment. It leads to a lot of really contentious issues. Whereas if you had this document that clearly lays out what your wishes are, when you were in your right mind to sort of think through that, it's certainly not, it doesn't prevent all family issues, but obviously it helps minimize that being one of the ones that causes a lot of problems.
Okay. I mean, this pain management, specifically my mom, when she passed away, we were all right there with her. Having her have been real clear on what she wanted us to do gave us the flexibility to keep her out of pain, which was just a matter of hours for how long she was going to live. So all this stuff just comes along with the package with the people we're going to send you to. The healthcare power of attorney, very similar to the general durable power of attorney, but it relates to healthcare. So who's going to make the decision whether they're going to do surgery or not? Or who's going to make the decision about whether you can go home with home health care or you're going to go to the rehab, but when it's time to come out of the rehab, do you go to assisted living or do you go home? And then once you go home, who's going to make the deal with the home health care agency that's going to provide the care and then look after your parent or yourself and then your spouse too? I mean, there's all these things. This allows you to do the business of healthcare and to deal with the doctor and to make healthcare decisions with a legal effect. Tom?
Yeah, and I think on this one, and it's similar to the durable power of attorney, except it's more on medical questions as opposed to financial issues. And what I would recommend on both of them is naming like one person, and you can have contingent ones. So you could have like, say you have three kids, you could name all three there, but I would have it like, I name, my oldest child first, my middle one next, my third one next. You want to have an order there because you are allowed to name them jointly where but then they all have to agree on getting something done. And again, that just potentially has problems there. Whereas if you give one person the authority to make the decisions, it allows things to actually happen to get done as opposed to them fighting amongst themselves. So that would just be a piece that I would sort of recommend. But again, it's important to have this medical power of attorney and allows them to make those medical decisions on your behalf because presumably you're not able to do so. The doctor's asking questions you can't answer, your healthcare power of attorney can come in and make some decisions. And a lot of times, whatever decision is better than no decision at all. And so, again, having something like that is super important. The next one on the list is the HIPAA authorization. um, Again, this is sort of similar to the healthcare power of attorney, but what the HIPAA authorization does is it allows the doctor to release the medical information to you. Whereas the healthcare power of attorney is helps you make decisions on their behalf. HIPAA allows the doctor to give like their medical records or something like that. A lot of doctors' offices have their own form that you might have already filled out, which is great. That will probably you wouldn't need this document in that scenario. But let's say something happens, you're seeing your primary doctor, you filled out the HIPAA authorization with them, you can talk with them, and then you get transferred to like a hospital, or you get transferred to another specialist, and they don't have that form on file. They're not going to use the other doctor's form. But if you had this document, you could provide that, and it would allow them to release your information to whoever you've named as that who has that authorization. Again, it's just a way to sort of head off some potential issues that could arise down the road.
Yeah, you're definitely going to want to have one of these. I mean, if I'm your son and you know, I'm going to want to be, or one of my sisters is going to be the general durable power of attorney. I'm going to be that. I'm going to be the healthcare. But in addition to that, I want this HIPAA authorization. Well, I can't even make a doctor's appointment for you, or I can't call the doctor and inquire about something or get. You need. This is really for protection for the doctor, so that they will release information to you. So you want this thing that covers all medical providers. Um, Now we're jumping into the areas of stuff you're not going to get from the attorney, but we're going to talk about beneficiary designation. So all IRAs have a beneficiary designation on them that you don't want to put down the estate because that's just going to put it right into probate. So you want to name real living people as your beneficiaries. And um, whether it's an IRA or it's a life insurance policy or it's an annuity, any type of insurance policy is going to have a beneficiary designation on it. And that money that's in the policy is going to be paid directly to the named beneficiary. End of story. It's going to bypass probate. I mean, that's the goal. And especially when people don't have trusts, we're going to take anything that has anything that is, it represents money or is a financial statement. It's going to either have a beneficiary designation, or if it's a brokerage account or an account at the bank, it's going to have a transfer on death or a TOD, which acts very much like a beneficiary designation. Is whoever's named as the transfer on death, or it could be two people, that money just automatically transfers. It doesn't go through the probate process. It's going to be just providing a death certificate and identification that you're the person that's stated there, claim form with an insurance policy. So our goal when we're doing estate planning is to have as much stuff pass according to the way you want it to quickly through the use of either a beneficiary designation or a transfer on death. Um, I want to make it clear that these things, both of them, trump the will. So if the will says one thing, it says that I leave all my money to Sally, but the beneficiary designation says I leave this money to Joseph. Joseph is going to get that money on the beneficiary designation long before the will's even read. And when the two conflict, this wins. Okay. Tom?
Yeah, I mean, I think like Hans mentioned, the goal in estate planning often is to have things pass outside of the will, avoiding the probate process. And beneficiary designation, transfer on death designations work wonderfully, right? It works smoothly, and this is where I have some contention with some of the lawyers that are using a trust to do this. They say, "Oh, the trust, well, yeah, that's what the trust is there for," which the trust certainly works, right? I'm not saying the trust doesn't do that, but it adds another layer that's maybe not necessary, right? If all you have is sort of simple things, nothing complicated, or leave everything to my spouse, or if you're not married, to my kids, whatever that is, and it's very clear, why don't we just use beneficiary designations to do that? If the sole purpose of the trust is just to bypass probate, a lot of times there's more simple ways to do that through these designations. Now, not all the time, right? Trust can be very useful for property, real estate, those type of things, because oftentimes you can't name those. Some states have transfer on death deeds where you list it just right on the deed, which works kind of like a beneficiary. But again, that's state by state specific. So it might not be in your state. But your bank accounts, your IRAs, your financial accounts, all of those have a way to list a beneficiary where things just pass directly to them. They don't have to go through the trust. And it's just a simpler way to do it. And so, again, I think overall, the goal is to have as much as we can pass to who we want it to go to without any complications, without being caught up in the courts, and just really smoothly. And another thing, like Hans mentioned, is these supersede the will. Like they happen before the will is executed. So if you have something on the account, we've seen this with beneficiary designations. I mean, they're really great, but if you don't check them and don't review them, it can cause problems. So I've seen several where they've had ex-spouses named as a beneficiary and they never changed it. Say, oh, my will says to leave everything to my kids and not my ex-spouse. It's like, well, I mean, I know your will says that, but what the company has on file is your ex-spouse, and they're going to send it to them, and they are not going to send it to your kids, even though your will says something different. So if you haven't checked these designations recently, or you're unsure what they say, pull them out, take a look at them, make sure that they are in line with what your current wishes are, and maybe not what your wishes were 20 years ago.
So you do financial planning with us. We do a financial plan, write one for you. We're going to get all this stuff out. We're going to check all this stuff. Okay. We're going to see what all your beneficiary designations are. We find stuff all the time that they're not what people thought they were, or they hadn't looked into them. But that's part of our checklist and our process. And if there's any transfer on death on accounts, same way. Now, in an ideal situation, and when you get done with us, we send you to an attorney and we're going to get the will written and all the powers of attorney, and we're going to get all 5 of those documents done. We're going to make the will mirror the beneficiary designations and the alternate beneficiary designations. We're going to take those two mirror each other so that they're in sync. So we know that if the beneficiary is how it's going to get paid out, but we're going to have the will say exactly the same thing. And if you later change one of those things, you probably ought to change both the will and the beneficiary designation, because you don't want those out of agreement. If they're not in agreement, this is going to win. So when people do financial planning with us, we get all this stuff out and we check it. And we generally don't send people to the attorney until we've done the financial planning for them. So we really don't want a lot of calls where people are just asking us, all they want is this. They don't really want to use us for estate planning, but yet they want us to make a referral to an attorney. It's hard for us to do that because we don't really know what you need. And we're going to learn all that through doing the financial planning for you. And our financial plans are like all these series of videos. Is estate planning is just one piece of the financial plan, is who do you want your money to go to in the end? And then all these legal documents are how can we facilitate that in the simplest, least expensive way that happens quickly. What we've talked about today is we've talked about taxes. And so when I go back to trust, there's a lot of trusts that can be set up to reduce or eliminate, estate taxes or income taxes. Um, so there's ways we can use a trust. These are generally higher asset people, higher income people, but we can use trust, not a revocable living trust, but some other type of trust to accomplish some other objective, which many times is taxes. What we talked about today, the 401k and IRA, I want you to just be real clear on this. You can't put an IRA in a trust while you're living. It has to stay in your name. You can't even put it in your spouse's name. Now, when you die, it has a beneficiary, and now it's in that person's name as an inherited IRA. So, just understand that it's different with IRA money as to how you can name and who can own it. We haven't really talked about long-term care other than the fact that it's during the long-term care discussion that people get this power of attorney and the healthcare power of attorney. That's what people end up realizing is that when you need long-term care, when you're getting it at home or you're getting it at the assisted living, it's generally going to be your adult children stepping in, sometimes your spouse, and they're going to need all these documents to properly take care of you and enable the caregivers to take care of you. We haven't really talked about Medicare or Social Security. So I want to bring Tom back on. I'm Hans Scheil.
And I'm Tom Griffith.
And we thank you very much for listening.
Thank you.